Hello, this is a meeting with Kate Thompson of the State Ethics Commission. She's kind enough to join us to discuss ethics compliance at the state level. Kate?
Hi, okay, thanks. Bi-county commissions are covered in some and to some extent in the public ethics law, which is the part of law that that our office is in charge of. And just so you know, parks and planning is not explicitly talked about a lot in the law. It's defined as one of three bi-county commissions. So in the ethics law in 550, in the general provisions, Article 5, they talk about bi-county commissions. They're all treated exactly the same. So that's parks and planning, which I'll abbreviate as parks and planning, if that's all right with everybody. So I don't have to say the whole name every time. WSSC, right? And the Washington Transit Suburban. Is that what it's called? The Washington, what do they call it? The Washington
Suburban Sanitary Commission?
Yes, no, the sanitary is one, and then the Washington Suburban Transit Commission is also one. Yeah, those are the three. And what the law says is that the commission members of those three commissions, so the commission members of the bi-county commissions, including Parks and Planning, those appointed commissioners that sit at the very top, are covered by the public ethics law. That's our office. We have jurisdiction over their conflicts of interest and over their financial disclosure filings, and the enforcement of them. So if they take inappropriate gifts, if they have outside employment, if they participate in a matter that they have a specific interest in, those would be our jurisdiction for any violations for the commissioners. So that's the easy part, right? That's what I do every day. We also cover all 84,000 state employees, all elected officials in the state also. The part where—
So if they went out and bought a piece of property that they knew was going to get, something proposed to be built on or something like that, that would be the kind of personal ethical kind of conflict.
And board members are sort of interesting. So the big thing for state employees that we do a lot of work on is secondary employment and financial interest. So in our office, we regulate lobbyists. I could not work as a lobbyist because I would regulate myself, right? That's an inherent conflict of interest. For our board members, we allow them to carry conflicts because we assume they have conflicts, right? So the cleanest example of that is like the nursing board. The ethics law says you cannot, in theory, it would say that you can't sit on the nursing board and be a nurse, but that doesn't make any sense, right? We want nurses on our nursing board. So what it says is that you can be a commissioner, you can sit on boards and commissions and regulate yourself as long as you disclose that conflict when you're appointed. You have to disclose it when you're appointed, and you refrain from participating in anything that you have an interest in, right? So Parks and Planning is a great example. If you said that nobody sitting on the Parks and Planning board could have any property in the entire county, you would have nobody appropriate on the board, right? You want people with experience on this. So what people in those positions do is when they're appointed, they would say, all right, I own this property, I have this business. They will be appointed even knowing they have those interests, and then they cannot participate in a matter in which they have a specific interest. That specific interest really matters here, right? Because if they were voting on a plan for the whole county, like a total rezoning, their interest is not any different than anyone else's. If they're voting on a specific up zone or down zone of their particular property, they would not be allowed to participate. And if they did, those violations would come to us, right? So that's the commissioners. The legislature made a different choice when it came to the employees, though, of the Bi-County Commission. So every employee of the Bi-County Commission is not covered by our office. So the ethics law says really clearly that one of the only thing that we are involved in for Bi-County commissioners is we cover the commissioners, but that we're responsible for holding on to their required regulations. So each Bi-County commission is required to have conflict of interest regulations that match our law. They're required to have financial disclosure provisions that match our law for employees. So in theory, there should be regulations at WSSC, at Parks and Planning, and at the Suburban Transit Commission that match our law for the employees, that say the employees can't have secondary employment, they can't take gifts, they can't participate. That actually matches the language for local governments. So local governments, municipalities and counties have that same requirement. They have to have local laws for their elected officials, for their employees that match state law. But there's a huge difference between how those things are enforced. So for local governments, Montgomery County is a great example. If they were going to change their local ethics law, they have to send us a copy and we have to approve it. The law explicitly says we have to approve it to see if it matches and meets the standards outlined for similarities, right? And if it doesn't match, we send them a letter back. We call Moose Cobb and we say, Moose, you need to fix your law. It doesn't look good. And we can sort of like negotiate and have some sort of jurisdiction over what the language of their law says. The bi-county commissions, and I don't know why this was enacted in the 1980s. The legislature said, we don't, my guess is that the local government didn't want us meddling too much. But the law says that we don't approve their law. They submit their regulations to us. That's it. That's what it says. It says they shall submit them. When it comes to financial disclosure for conflicts, it just requires them to file a copy of their regulations with our office. That language was so different from the local government language that we actually wrote a letter to the Attorney General in the 80s asking him to clarify, being like, this seems odd. You just want them to send us a copy. We don't review it. We don't approve it. And they wrote us a letter back saying basically, no, your only job is to give comment. So like say, this looks like it matches or it doesn't. And then to be a repository. That's it. So that's for employees. And they did that exact same thing for lobbying as well. So each bi-county is required to have lobbying provisions that are similar to our law and then required to submit them to us. And we have no enforcement over that. So they could submit us a lobbying regulation that literally says, we don't have a lobbying law. We have to keep it on file. We will send them a letter back saying this does not match the provisions of the ethics law, but we have no jurisdiction at all over enforcement of that, of making them match. We can make our notes public, which all of the files are public here, but we don't have any jurisdiction over that. So we're getting lots of complaints, validly, right? You guys had, the Parks and Planning basically admitted that they had not been keeping track of lobbyists. They had not been filing open meetings. But people who came to us to complain about it, we don't have any jurisdiction, right? If we filed a suit saying your laws have to match our laws, they would just file a motion to dismiss saying you don't have authority over the contents of the regulations, and they would be correct. And they have not only the law, but they have this AG letter to support them as well. So, like I told Alan when we talked to her, I'm happy to answer questions. I think really realistically, the solutions here for especially the lobbying issues are going to be lobbying them to change their laws, which it sounds like Adrian and his team at Parks and Planning are working to do. And then to think about a legislative fix, which Al Carr is working on. They're having a voting session at noon on Al Carr's bill that will require bi-county commissions, when they file these regulations, to not just file them, but attach a certification under oath that they meet the requirements of the law. So it will not give us any more power, but now it requires them basically to perjure themselves if they are not following those rules. So I think that is a good step. I think in talking with all of the commissions, and I will just say this, in talking to the attorneys with all the commissions, I haven't talked to WSSC because theirs are more strict, but recently I've talked to the attorneys for both Parks and Planning and Suburban, who do not meet the requirements currently under the law. There is a desire to be in compliance with the requirements and the spirit of the law. I think they're, from Adrian's letter, which everyone could see, that public letter, there was an admittance of we might have dropped the ball here and we're going to try and make it right. And that is the feeling that we're getting here too. So we have all copies of all of that stuff here, of their filings over the last several years. But other than that, we don't have any jurisdiction to go after them for lobbying or ethics issues on the employee and the lobbying level. And like I said, I'm happy to answer additional questions because I think it's kind of complicated, but that's just sort of the way the legislature wrote it.
Kate, I've got a couple of questions. I'm sure other people do as well. Does State Ethics Commission anytime do they present to the legislature and suggest desired changes in state legislation?
We put desired legislative changes in our annual report. For bi-county commissions, I don't think we have any suggested changes. Like I said, I think there are good people can have lots of feelings about what the solutions here would be. In general, the Ethics Commission tries to does not do a lot of legislative leading, right? Because that's not our calling. It is not to drive legislative agenda, right? That's supposed to come from constituents and legislatures. We rarely take positions on bills. We rarely put in our own bills. We offer comment, we offer suggestions, we provide background and information. And again, especially with the bi-county commissions, the law, I think the law as it written, if it happens correctly, works pretty well. If the problem is it just has not been meeting the standard. And I also think when you talk about bi-county commissions, you have to acknowledge how different all three are. And so the way they're grouped in the law, one of the things we've said in like we said to Delegate Carr, is that a change that you make to this part of the law will affect WSSC, it will affect Parks and Planning, but it also affects the Suburban Transit Commission, which has 2 employees. So, any legislation should be thoughtful about all the impacts that it's going to create, like it always should. And so, like I said, we've been working with Delegate Carr a lot on that legislation, but we rarely have, that's usually the role we take when it comes to legislative issues.
So, it struck me as Al's legislation was sort of low hanging fruit and, just requiring compliance should be something that everybody could get behind. But I was wondering whether or not state ethics had ever suggested that the state ethics requirements apply to all employees of bilateral commissions instead of just to the commissioners, and wondered if you had ever advanced that idea to the legislature.
No, definitely not. We, like I said, looking back at the legislative history, there was a lot of discussion, I think, about who these people should belong to. And, the same thing, every couple of years, there's some discussion about whether we should be in charge of all of the local governments too, right? Like if there's a Montgomery County ethics issue, if it should come to the state level. And I think, it's a tension, right? Like how much do you want to happen in-house and how much do you want to keep under local control? And I think the thought is that especially the commissioners who are appointed by the governor and by some of them are appointed by the governor and by state officials sort of fall under our state umbrella, but that the employees of these commissions function more like county employees. I have seen some counties put these kinds of people under their county ethics law, which is another way you could do it as well. But like I said, that kind of like suggestion of like, we think these people should be ours is not the kind of thing that just like legislatively is not the kind of thing that we normally do. Like I said, if the bill came in, we would say this would add this many people to our governance, this would be the impacts of it, but it is not something that we've ever, like I said, it's not a departmental that the commission has ever put forward.
The second piece of that is, have you or have any legislators address the enforcement piece, giving State Ethics Commission the enforcement power and authority that you don't have now?
Not that I know of.
Would that be something that you'd be interested in?
Again, none of this, I don't make these decisions. The commission makes the decisions. And I've been with the commission for 10 years. Overwhelmingly, they do not take positions on bills. They feel really strongly that the legislature should drive like the legislative decision making, and we should just take our lead from them because that's their wheelhouse, right? They have a good sense of the policy and the implications. And then they're really close to the constituents too, right? Like, do constituents want this to go in Montgomery County or in PG County? Do they want it to come to the state? And so there's a sort of, I think, a more holistic view when that comes from the legislators instead of from our office.
And then in one of your answers, you mentioned open meetings in passing. As I understand it, that does not come under state ethics, and that's an open meetings board.
Yeah.
I just wanted to clarify that you don't have anything to do with the Open Meetings Act.
No, we do not.
Okay. Who else has got questions for Kate Thompson? Jerry Garson.
We've in the past, the Montgomery County Civic Federation has worked with various members of the state legislature in putting in inspector generals for WSSC, park and planning. We now have a Montgomery County Board of Education under the county's inspector general, and Montgomery College under the county's inspector general. Is there any specific wording or other legislation if we try to change all these rules, and that the Civic Fed can work with members of the state legislature to try to get these rules or regulations enacted? And the second question is, do you have oversight over like Montgomery County Board of Education, which is really under the State Board of Education? Do they have to have ethics policies? I know we've had problems in their transportation area recently.
Yeah, so all the boards of eds in all the counties and in Baltimore City also have, they call them ethics policies because they don't have laws, actual local laws in the same way. So they all have to have an ethics policy that's required. It has to match state law. We review those, and we do have the power to approve or disapprove them if they do not meet the requirements of our ethics law. But the enforcement of them happens locally. So if you saw something wrong with the Montgomery County ethics policy, like it just didn't include gift provisions at all, that's something we could address. But if you saw a violation of the law itself, it would happen locally. But they do have an ethics law. My husband works for Anne Arundel County Public Schools, so I can't do anything involving them, which is my own ethics requirement. But then every year he fills out a financial disclosure for them, which is what our law has told them to do. So yeah, they have a law at the Board of Ed, and their policy should be available on their website, and you can look through it and see what's in it. But it matches our law as required. I think all the boards of ed, they changed the law last year, so they're all making amendments now. But all the boards of ed had previously been in compliance before the law changed last year. And for your first question, I'm not sure, again, I'm not sure what language you want, because I don't know what the end goal is, right? Do you want the requirements for the bi-counties to be stronger? Do you want them to come to us? Do you want it to be more clear? And so I guess, like I said, legislators and their bill drafters are always going to be the best resource for figuring out how to write a law that drives the policy that you want. I am not a bill drafter. I can barely read them when they come across our desk. So, I think the legislators are going to be your best resource there.
Thank you for your answer.
Yeah.
So some clarification. So if the bilateral commission, planning commission, Prince George's and Montgomery MNC PPC did not have a gift provision in their ethics framework, state ethics couldn't do anything because the commission is only submitting their regulations, and they don't have to be improved, and there's no comment. So if they didn't have a gift provision, there's nothing you could do, at least for the commissioners, and you have nothing to do with the employees.
So for the commissioners, they are covered by our public ethics law. So I know there's a gift provision that covers them. For the employees, you're right. If they sent us the copy of the regulations and they didn't have a gift provision, we would send a note back saying, this is not similar to the state ethics law. Your regulations are not similar, but that would be the limit of what we could do.
And you mentioned that there have been has there been upsurge in complaints and concerns, inquiries about bilateral commissions over the last year or recent years around the lobbying, gifts, conflict of interest questions?
I think we can never comment about specific like complaints that we get. But I will say in the last 2 years, I know last year legislatively, there was a huge bill about the PG County zoning. Um, and because I'm not even going to get into it, but we are tangentially involved in PG zoning because their zoning law is in our law, so it's kind of a confused mess. But so anytime there's a change in our law and legislative overlap, we get a lot of calls, right? People want to know why didn't you do anything? What's going on? We get calls from legislators. We appear at testimony saying what we, our understanding of it, and so then people call us. And I think anytime there are lobbying issues and conflict of interest issues, we get a lot of calls because if you Google Maryland ethics, we're going to be the first thing that comes up. So I will tell you, I've had a lot of calls of people saying, where do I go if I have questions about this? And so we do a lot of sort of referring, like, oh, call Parks and Planning, or you can come to us for commissioners and stuff like that. So I think anytime there are bills, the calls go up for sure. We've been getting calls on all our bills, all of them.
And
I say ours, I mean the ones that affect our law, because none of them are ours.
are you the first person that people get to talk to at the commission when they have a concern at the local level? I mean, do you
No.
field all those questions, or is there a process where people talk to somebody before they get to Kate Thompson?
You call our office, and if you say you have a local government question, you get an attorney. So there's 4 attorneys here. Our local government sort of arm is housed in advice. We have an advice side and an enforcement side. I work on the enforcement side. So if somebody says like, oh, I have a question about local government compliance, it'll go to advice. But if you say like, oh, I think a local government is violated, it'll come to me because of enforcement. But in general, we're happy to answer questions. It sort of just depends on who's here that day.
So
I got a couple.
Go ahead, Karen.
Yeah, I had just a couple of quick ones. One is Montgomery County and Prince George's the only ones where there's a bi-county or tri or whatever county commissioner, or there are ones elsewhere in the state?
So like I said, there's 3 defined bi-county commissions under our law, and WSSC, Parks and Planning, and then the Washington Suburban Transit Commission. And I'm not even sure.
I'm looking like elsewhere, like is there, like around Baltimore, are there multi-county commissions there or anything like that? Or
there may be, but they're not covered under our law.
Okay. Second question, with all this, is there anything in your all's experience or the legislative history or anything where what they sort of expect, who's going to enforce these against either the commissioners or the employees, where that enforcement might come from if there was a violation? Is there a sense of that?
I think the intent was for enforcement for commissioners would come to us, for sure. That's clear in the law. And I think the idea was because the commissioners' enforcement goes elsewhere, they would be responsible for enforcing the employees, right? So I think the way it's supposed to happen is you have an ethics regulation for Parks and Planning. If you think an employee has violated it, a citizen could file a complaint with Parks and Planning's attorney, who would take it to the commission for their review. And because they go up, they would be the ones enforcing it for their own employees. I think that was the intent.
So if employees were doing things and it was clearly being brought to the commission didn't do anything about it, is that something that would be looked at as a commission violation?
I mean, I guess it would depend. They would have to violate. It wouldn't be a violation on its own. Like failure to do a good job, right, is not a violation on its own. It would have to be another violation. I think then the call becomes with appointments, right? Whoever makes the appointment, that this is a bad appointment, that they shouldn't be reappointed. I think that would be the solution, is that you have a bad commissioner, and so you need someone better in that commission role. But yeah, I mean, we see this all the time, right? Like if there's some discretion, right, at that level. But I think the idea would be, as a commissioner, you take a fiduciary duty to do what's best for Parks and Planning. And so that would be, I mean, there's an assumption that I think there's an assumption that those people should be doing what's in the best interest of the commission. And if they aren't doing it, it's not an ethics issue. It's you need a new commissioner issue. And I don't want to sound flippant about that, because that's not like, you can't just replace them ad hoc. But I think, I mean, I tell people the same thing too. When you have a bad legislator, the solution is to get a new legislator. And again, that is not a simple, I'm saying it like it's a simple thing, which it's not. But I do think that's the way the process is designed to happen in a perfect world.
What are the terms for 4 years or some other time limit or anything? Or
I have no idea. I have no idea.
Okay. We can find out.
Kate, so if a resident had a concern that a commissioner from WSSC Park and Planning had a conflict of interest, perhaps owned a piece of property and it's going to be covered by a zoning proposal, or the county is going to acquire some of their property, what would be the procedure for a resident to sort of make a complaint and bring that to the attention of the commission?
Yeah, so the complaints can be made and they have to be written. So, but it can be an email or regular mail. They have to be signed, which again can be electronic, under oath, which just means sort of an affirmative statement. Like, I affirm that the things I'm saying are true. We ask that they be notarized, but they don't have to be, and that they allege a specific violation of ethics law. So you would write a letter to our office, address it to me and say, you know, I affirm these things to be true. I believe that Commissioner X has violated the participation provisions of the ethics law by participating in a matter in which they have a specific interest. This is the, you know, the more information, the better, right? It's just me and 2 paralegals for 84,000 employees and board and commission members. Then I can go and I can pull the tape and I can pull the SSTAT records, and we could see very quickly. Participation is really simple. You can never participate in a matter in which you have an interest unless there's a quorum issue and you've disclosed your conflict on the record. But yeah, those complaints would come in that form to our office, and then whoever's making the complaint, we would talk through, sort of the process from there.
So you said at the outset, you have to disclose your conflicts at possible conflicts at the beginning of this process. If a resident alleged violation of the rules with that conflict, is the fact that somebody has acknowledged at the very beginning, take that off the table?
Well, so the conflict allows them to hold the property, not to participate in the matter. So, like I said, normal ethics laws would say you cannot sit on the Parks and Planning Commission and have a financial interest in any entity that does business with or is regulated or under the authority of your commission. So that allows you to hold those conflicts but not participate in them. So in this scenario you described, you could never get out of the participation. The only exception to that being, like I said, there's a very specific exception for board members who are allowed to participate only when there's a quorum issue. The quorum issue is noted on the minutes, the conflict is noted on the minutes, and then they can participate even with a conflict. That's rare. But that would be the only other time where, like, I might do a little investigation and then say, like, they did participate, they did have a conflict, but they went through this exemption procedure and they're okay. And again, that would only apply to commissioners, not to employees.
And then as we wrap up, and we appreciate your time, we've learned a lot, so thank you so much. If a commissioner has, particularly a commissioner for one of these commission, has an ex parte communication that would normally not be allowed under their commission rules, does state ethics have any interest in that? Can somebody complain about an ex parte communication between a bilateral commissioner, bi-county commissioner, and some interest group?
We do not have jurisdiction over commission policies and procedures, so we would not be able to help. But we would refer you, obviously, again, to whoever. I would think it would be the attorney's office in-house that would have jurisdiction over those things.
Thank you very much. Colleagues, any more questions for Kate Thompson at the State Ethics Commission?
quick clarification. Were you saying, did the commissioner have these ex parte communications, or was it an employee having them? In other words, my question is, does your state laws cover ex parte communications?
No,
So
not
that's
at all.
not in the state ethic law.
No.
Okay.
Okay,
When was the law passed that enacted these commissions, that governs these commissions?
I'm pulling, this is our original legislation file, so for Vice County Commissions, I'm pulling the file. So I have it sitting at my feet. And I don't know for sure, but I have, let's see. This letter is from right after enactment in 81. I think
Okay.
that our law
Wow,
only
okay.
passed in 79. And then I think the bi-county provisions were added in 81.
but the commissions were, well, at least WSS, MNC PPC was created early in the 20th century. At least that's my understanding. I mean,
Yeah, so they,
20s maybe.
they only added them to our sort of umbrella in the 80s.
So any more questions for Kate Thompson from State Ethics? Jerry Garson?
Do you need any more employees?
Yeah, we do. We actually, we have no more room. We're in like a tiny little Annapolis building, so we would have nowhere to put you. But no, we have 12 people and we work hard and we love it. I mean, I love it. I won't speak for everybody in the office, but you know, it's the more the merrier.
What about the commissioners? There are commissioners that you have, yes?
Yeah, we have 5 commissioners that are like
Appointed by the governor?
3 appointed by the governor, 1 that has to be of the opposite political party, and then 1 from the Senate President's office and 1 from the Speaker of the House.
Okay,
And they're really good. They're good.
that's good. That's good to know.
Yeah,
And,
we're lucky right now.
And your website is?
Maryland or ethics.maryland.gov.
Okay. We want to thank you, Kate Thompson from the State Ethics Commission, for talking to us this morning about ethics compliance, ethics regulations, and bi-county commissions. We learned a lot and we appreciate your insight and your information.
And feel free to give us a call if you guys do have additional questions. We're happy to try and help.